Yes, ready for dictation. 3, 2, 1, start. In any case, even if it is held that a writ petition against a non-appealable order of the arbitrator is maintainable, considering the legislative intent as expressed in Section 5 of the Act, which provides that no judicial authority shall intervene in matters governed by Part 1 except to the extent provided in the said part, and acknowledging that interference with the arbitral proceedings in exercise of writ jurisdiction of the court is bound to delay the conclusion of such proceedings, thereby defeating one of the main objectives behind preferring arbitration over litigation. The court would be well advised is not interfering with such an order in exercise of its writ jurisdiction, full stop. Keeping in view the legislative intent with regard to minimal judicial interference and speedy disposal of arbitral proceedings, the alternate remedies provided under the 1996 Act should be strictly followed, as holding otherwise would set at naught the very purpose for which settlement of disputes are resorted to through the mode of arbitration, full stop. This would also be in line with the directions issued by the Supreme Court in SBP's case within bracket supra, which have already been quoted and referred to earlier para. The submissions raised by learned counsel for the petitioner that subsections 5 and 6 of section 16 of the 1996 Act do not bar the jurisdiction of this court under articles 226/227 of the Constitution of India to quash an order passed by the tribunal under section 16 of the 1996 Act does not cut ice with this court, as acceptance of such an argument would not only be against the law laid down by the Supreme Court in SBP's case within bracket supra, but would also be in direct conflict with the legislative intent with which the 1996 Act has been promulgated, which is for speedy disposal of arbitral disputes with minimal judicial interference para. Learned counsel for the petitioner placed reliance on the judgment of the Supreme Court in Associated Cement Companies Limited's case within bracket supra to submit that the powers of the High Court under Articles 226/227 of the Constitution of India could not be curtailed, full stop. In Associated Cement Companies Limited's case within bracket supra, the issue which came up for consideration before the Supreme Court was whether the state, while exercising its appellate jurisdiction under the Punjab Welfare Officers Recruitment and Conditions of Service Rules 1952, was a tribunal within the meaning of Article 136 within bracket 1 of the Constitution of India, full stop. In that case, the Associated Cement Companies Limited had challenged before the Supreme Court the order passed by the state while exercising its appellate jurisdiction, and through which the state had directed it to reinstate respondent number 1 therein, full stop. At the time of hearing of the matter, an objection was raised that special leave should not be granted to the appellant, as the decision of the state under the aforesaid rules was not a decision of a tribunal, full stop. The issue raised in Associated Cement Companies Limited's case within bracket supra was clearly distinct than the issue in the present case, as herein the objection by the contesting respondent over.